What's up, guys? It's Lord Botha here, and Disney are douchebags. That's what people will be saying when they read this headline. Disney trying to move a wrongful death suit into arbitration based on terms and agreements of widow plaintiff's streaming subscription. This comes to us from Bounding Into Comics. Disney Corporation wants a lawsuit thrown out on a weird and, one would think, unprecedented basis. What's more, the suit is not frivolous in nature, as it involves the death of a patron at one of their parks and her widower. Per the New York Post, theme park goer Jeffrey Piccolo claims his wife, I'm not going to stumble through her name and disrespect her like that, an NYU doctor suffered a fatal allergic reaction shortly after eating at a Disney Springs restaurant in Florida last October. And yes, this lawsuit has been ongoing for some time, but it does seem to have just reached the mainstream news and be in the circuit again now. And that's probably due to the fact that D23 just happened, so any kind of lawsuits or bad press involving Disney is going to be even at a higher note now. In his original complaint, it states that the 42-year-old woman died of a severe allergic reaction known as anaphylaxis just hours after dining at the Raglan Road Irish pub and restaurant with her husband back on October 5th, after repeatedly stressing to the staff that she was definitely allergic to nuts and dairy. Now, what I have heard about this is that this restaurant on Raglan Road is not part of any Disney parks specifically. It is an affiliate and is their establishment, but you don't have to purchase a ticket or anything to get to the place where this restaurant is. It's accessible to the public directly. Piccolo is seeking $50,000 in damages, but isn't settling. That's right, you go after it, Piccolo. Speak to the people, Piccolo. They need to hear this. Defendant Disney is using terms of service against him. They say because the widower's Disney Plus subscription stipulates all disputes with the company must be arbitrated, which entails proceedings outside of a courtroom. If you don't know what arbitration agreements are, they're basically a legal agreement that says instead of going directly to lawsuit, you will meet with the company outside of a courtroom, try to see if you can find some sort of compromise, some sort of restitution for any potential wrongdoing or things like that. So what this lawsuit defense is essentially saying is because the widower, the husband that's still alive, whose wife died because she ate peanuts after being very direct that she had a peanut allergy to these people working at the restaurant, Disney is saying because they had a Disney Plus subscription, and that subscription included an arbitration agreement, and because that arbitration agreement was worded broadly and specifically meant to be vague, the legal team for Disney is now trying to argue that it also applies to any business operated by Disney. Now, it's not uncommon for lawyers and legal teams to try to use any kind of defense possible to defend their client. That includes trying to use defenses they know are wild, don't make a whole lot of sense, and probably won't work. And that's typically because that's the only thing that they have. But at this point, this defense is just making things worse. Now, not only do you have a horrible defense to try to get you out of a wrongful death lawsuit, you now have it put in the press that if people sign up for Disney Plus, and they keel over because of something that happens in one of your parks accidentally, that nobody has the right to sue you if something goes wrong because they signed an arbitration agreement with your TV service. It just makes Disney look like they're a scummy corporation that doesn't care about people. Which, yeah, there are thousands of guys all the way back to the 1970s that are now like, we told you so, man. Disney was always an evil corporation, man, that didn't care about the people. Well, yeah, we knew that. We just didn't ever think that they were going to accept the fact that they'd look like one. Their court documents add this defense was in effect as of 2019 when Piccolo signed up for a 1-month trial. If that means what I think it means that this guy, Piccolo, was not even a Disney Plus subscriber anymore. He signed up for 1 free month of the service and then canceled it. If that's so, that what they're saying here is that even if you sign up for just a month trial, you'll have to sign that arbitration agreement And that arbitration agreement is binding whether or not you continue to be a Disney Plus subscriber. If so, that sounds like a lawsuitable offense, because you're essentially using a free trial to trick people into signing a legal document that can affect them at other places of business. A motion filed in a circuit court last May contends the Disney Plus subscriber agreement Piccolo signed years earlier on his PlayStation called for any dispute, with the exception of small claims, to be resolved by individual binding arbitration. The company is likewise hiding behind similar language present in the agreement written into the My Disney Experience app, which Piccolo used to buy tickets for the trip and a visit to Epcot. His attorneys responded that Disney's justifications are preposterous, outrageously unreasonable, and fatally flawed. The notion that terms agreed to by a customer when creating a Disney Plus free trial account would forever bar that consumer the right to a jury trial in any dispute with any Disney affiliate or subsidiary is outrageously unreasonable and unfair as to shock the judicial conscience, and this court should not enforce such an agreement. They also countered that the suit was filed on behalf of the estate of his wife and not on behalf of himself. Piccolo is seeking damages under Florida's Wrongful Death Act for mental pain and suffering, loss of income, and funeral expenses. Again, I'm not a lawyer, but what it sounds like here is Piccolo's lawyer told him that Disney might try to pull some shit like this, so he probably had him file the suit under the estate of his wife's name, specifically so they couldn't use the arbitration agreement that he might have signed up for himself against him in this case. But there you sort of have it. This woman died of her peanut allergy after being served a contaminated meal at this pub that was owned by Disney Corporation. It doesn't seem like it was in a park, it was accessible to the public. So there's no arbitration agreement that could be contended within the ticket sales. And the argument that the arbitration agreement for signing up for a free 1-month trial of Disney Plus is hereby binding in all eternity for whatever might happen that's bad in life that Disney is specifically responsible to have done to you is absolutely ridiculous, and I think it's going to get laughed out of court. I don't know why they chose this defense knowing it would bring them so much bad press. Probably because it's the only defense that they had. But then again, they didn't do the proper balancing act, I think, between accepting that the lawsuit was going to happen and trying to give the best defense while not also coming up with something that sounds batshit crazy and makes your company look like evil, money-grubbing goblins who don't care about people. But those are just my thoughts on the Disney situation. If you have your own thoughts, go ahead and leave them in the comments. If you liked this video, please like, share, and subscribe. If you didn't like this video, I appreciate you listening to all of it. We'll talk to you again later.